All rise.
Hearing the appeal, RTS Flexible Systems Limited against Molkerei Alois Müller Gmbh.
Yes, Mr. McLean.
May it please your lordships, I appear on behalf of the appellant in this matter, together with my learned friend Mr. Michael Feely, my learned friends Mr. Stuart Catchpole and Charles Manzoni appear on behalf of the respondent. My lord, I wonder before I open the appeal, I might ask your lordships whether you would be willing to rise at some stage to give the shorthand writers a break. I've been specifically asked to ask your lordships that question.
Well, that we're not enthusiastic about, I'm afraid. If parties want to have shorthand writers for their convenience, that's fine, but it's not going to inconvenience the court. How long is the break that they're going to want?
5 minutes, my lord.
5 minutes. Well, shall we give them 5 minutes? A reluctant break for 5 minutes, but essentially, if the parties want to make arrangements to transcribe, that's up to them, but
yes,
not in circumstances which is going to interrupt the hearing.
Indeed, I'm grateful, my lord. My lord, in our submission, this is a case in which a traveller in the business section of the Clapham Omnibus would think that there's something very odd about how English law approaches the question of contract formation, where a commercial transaction has been completed or substantially completed. My lords, in this case, RTS and Müller agreed on the design, the manufacture, the supply and installation of 2 repackaging lines at Müller's premises for an agreed price of approximately £1.68 million. The equipment was supplied and installed, and Müller paid RTS over £1.1 million, being 70% of the agreed price. Afterwards, the parties fell out over the standard of performance of the equipment. RTS commenced proceedings and sued Müller for the balance of the purchase price. Müller counterclaimed damages for breach of contract, alleging that the equipment and services provided did not comply with the warranted standard. Now, it was common ground that the parties' obligations arose out of a contract, but the parties disagreed as to how that contract was formed and what its precise terms were. The High Court ordered a trial of a number of preliminary issues in order to determine what the parties' respective obligations were. At the trial of those preliminary issues, Mr. Justice Christopher Clark found as a fact that the parties had reached full agreement on the work which was to be done for the price which had been agreed. And that is at paragraph 72 of the judgment of the learned judge, which is at page 58 of the appendix, which your lordships find in the core bundle. The learned judge also found, as a matter of fact, that the parties' failure to agree on a schedule of terms and conditions was not an obstacle to a contract having been concluded. Following the trial, RTS appealed, and the Court of Appeal allowed RTS to advance a positive case for the first time on appeal that there was no contract between RTS and Müller after May 2005. The Court of Appeal accepted RTS's new case and held that there was no contract between the parties after May 2005. And in consequence of the Court of Appeal's decision, my lords, RTS supplied, delivered and installed the equipment and made demands for payment, and Müller paid £1.1 million without there being a contract in place. Now, the Court of Appeal gave 2 reasons for overturning the trial judge's determination, both reasons of which reflected RTS's new positive case. First, the Court of Appeal held that Mr. Justice Christopher Clark would not have reached this decision that he did reach if it had been referred to certain dicta of Mr. Justice Goff, as he then was, in the case of British Steel Corporation and Cleveland Engineering. Second, the Court of Appeal held that the effect of a counterparts clause in the draft terms and conditions was a complete answer to the conclusion that a contract had been formed. As the Court of Appeal recorded in paragraph 1 of its judgment, RTS on appeal expressly disavowed any challenge to any of the judge's findings of fact. Now, in their judgment, the Court of Appeal did not state explicitly that they were interfering with any of the judge's findings of fact. So the natural assumption would be that the Court of Appeal overruled the judge's determination on the basis that he had made some error of law. But in our submission, my lords, the Court of Appeal's reasons for setting aside the judge's determination are somewhat shortly stated and opaque. And we shall be submitting that the Court of Appeal's decision is either based on an error of law concerning the principles to be applied in connection with the formation of contracts, where parties have fully performed or substantially performed the transaction, or an improper interference with the trial judge's determinations of fact in response to a positive case on the facts which was not made by RTS at trial. So, on one level, my lords, this appeal is concerned with the principles governing the formation of contracts, where a commercial transaction has been fully or substantially performed. And on another level, it's concerned with the fundamental principles of fairness and justice that underpin a court's refusal to permit a change of case on appeal after a trial has been heard, unless it's satisfied that there is no risk of prejudice to the other party. My lords, I propose to make submissions in the following order. First, on what we submit as the orthodox approach to performance on the question of contract formation. Second, to consider the judgment of Mr. Justice Christopher Clark and the findings that he made, and then to examine how the Court of Appeal dealt with that judgment. I will then turn to the decision of Mr. Justice Robert Gough in the case of British Steel, on which the Court of Appeal placed considerable reliance. I will then consider the counterparts clause, clause 48 of the draft terms and conditions, which the Court of Appeal considered to be a complete answer to the claim. And finally, we will make our submissions as to why, in any event, we submit the Court of Appeal was wrong to permit this positive case to be run for the first time on appeal. My lords, turning now to the question of performance in connection with contract formation, we submit that the orthodox approach to contract formation in English law in a case such as the present is to treat performance of a commercial transaction as a matter of the first importance, not a matter of no importance. And the principle is pithily expressed by Professor Tritle in Civ on Contracts at volume 3 of your Lordship's Authorities Bundle, tab 36. This is an extract from the 30th edition of Civ on Contracts, the first volume. General principles dealing with the formation of contract, and paragraph 2028 is the paragraph I direct your Lordship's attention to. The learned author says, when parties carry on lengthy negotiations, it may be hard to say exactly when an offer has been made and accepted. As negotiations progress, each party may make concessions or new demands, and the parties may in the end disagree as to whether they have ever agreed at all. The court must then look at the whole correspondence and decide whether on its true construction the parties had agreed to the same terms. If so, there is a contract, even though both parties or one of them had reservations not expressed in the correspondence. The court will be particularly anxious to hold that continuing negotiations have resulted in a contract where the performance which was the subject matter of the negotiations has actually been rendered. In one such case, a building subcontract was held to have come into existence, even though agreement had not yet been reached when the contractor began work, as during its progress outstanding matters were resolved by further negotiations. The contract may then be given retrospective effect so as to cover work done before the final agreement was reached. Now, in the same bundle, my lords, at tab 43, one has an article written extrajudicially by Lord Steyn in 1997, entitled Contract Law Fulfilling the Reasonable Expectations of Honest Men. And your Lordships will see that at the start of this article, Lord Steyn said, a thread runs through our contract law that effect must be given to the reasonable expectations of honest men, Sometimes this is made explicit by judges. More often it is the implied basis of the court's decision. I'd like to examine what this means and to relate it to some parts of English contract law. It's an important subject for the future development of English contract law. And I would like to direct your Lordship's attention to the bottom paragraph of the page, where Lord Steyn addresses what is the status of this proposition. He says it's of some relevance to consider the status of our proposition. It's certainly not a rule of law. It is possible to argue that it is a general principle of law, such as, for example, the principle that no man may benefit from his own wrongdoing. I prefer to regard it as a central objective of the law of contract. The function of the law of contract is to provide an effective and fair framework for contractual dealings. This function requires an adjudication based on the reasonable expectation of parties. It's right to acknowledge, however, that the reasonable expectation of parties cannot always prevail. Sometimes they must yield to countervailing principles and policies. For example, other values enshrined in law and public policy may render the contract defeasible. Nevertheless, the aim of protecting reasonable expectations remains constant. Then he continued, it's now possible to examine how English law of contract measures up to this policy. Inevitably, I will have to be selective, but I hope to look at topics that are of considerable practical importance. The first relates to the formation of contracts. The classical doctrine is that a contract can only come into existence by the congruence of a matching offer and acceptance. As a general proposition, this makes sense, but it does not solve all cases satisfactorily. Take, for example, the so-called Battle of Forms cases, notably in the field of negotiations for the conclusion of building and engineering contracts. Each party insists on contracting only on his own standard conditions. In the meantime, the work starts, payments are made. Often it is a fiction to identify an offer and acceptance. Yet reason tells us that neither party should be able to withdraw unilaterally from the transaction. The reasonable expectations of the parties, albeit that they are still in disagreement about minor details of the transaction, often demand that the court must recognise that a contract has come into existence. The greater the evidence of reliance, and further along the road towards implementation of the transaction is, the greater the prospect that the court will find the contract made and do its best in accordance with the reasonable expectations of the parties to spell out the terms of the contract.
Yes. How much of your argument is going to be focusing on what the reasonable expectations of the parties were? Because your outline looks rather as though you're approaching this case as it's either the Court of Appeal was right or Mr. Justice Christopher Clark was right. But there's a possibility that neither was right.
There is a possibility that neither was right.
The court is certainly going to need assistance in looking at that possibility.
Certainly, my Lord. The approach and the guidance given by Lord Steyn in this article, and the case to which he refers in it in footnote 3, which is the Percy Trentham case, is essentially how Christopher Clark directed himself at trial, basing himself on the guidance of the Court of Appeal in the Percy Trentham case, which is, in our submission, the leading modern authority at Court of Appeal level on performance is relevance to the formation of the contract. Now, in the present case, the Court of Appeal held, as your Lordships know, that Mr. Justice Christopher Clark was wrong to focus on the Court of Appeal's guidance in Trentham. As they said, in paragraph 56 of the judgment, the judge's focus was unfortunately on Lord Justice Steyn's approach. That's paragraph 56, page 24 of the bundle. And they said at paragraph 47 of their judgment that Lord Justice Steyn's approach dictated the way in which the whole case was perceived. Their approach was to say that the learned judge should have been guided by certain dicta of Mr. Justice Robert Gough in the British Steel case. And this is the first occasion, so far as we're aware, on which these dicta have been applied in the way in which the Court of Appeal applied them. The case is a well-known case, but on other issues, and I shall be in due course, as I said, examining whether the Court of Appeal was correct to treat it as some form of general principle. But one of the most striking aspects, my lords, of the Court of Appeal's decision is that it apparently attached no weight or relevance to the facts that, as the judge found, RTS designed, manufactured, installed 2 lines of repackaging equipment, purportedly in accordance with specifications which the judge found had been agreed, that Müller supplied free-issue equipment, as the parties had agreed, for integration into the packaging lines, and 70% of the contract price was paid. Now, we submit that in holding that the judge should have applied these dicta in the British Steel case in preference to what I've described as the orthodox approach of Lord Steyn and Trentham, the Court of Appeal has allowed the law of contract to take a wrong turn. In summary, we say it's taken a wrong turn because the Court of Appeal's approach seriously attenuates the relevance traditionally attached to performance in the case of contract formation, as explained by Lord Steyn in his article and by Lord Justice Steyn in the Trentham case. It introduces a further area of uncertainty into the question as to whether a contract has been formed, where the classic offer and acceptance analysis cannot be applied. And in so doing, in our submission, the Court of Appeal's approach undermines what Lord Steyn identified as the central objective of the law of contract, namely to give effect to the reasonable expectations of sensible businessmen. Now, I'd like now to turn, my lords, to the Trentham case itself, which your lordships have at tab 15 in volume 1 of your lordships' authorities bundle. Now, in Trentham, my lords, the Court of Appeal panel consisted of Lord Justice Neal, Lord Justice Ralph Gibson, and Lord Justice Steyn, who gave the judgment of the court. It was a case where the claimant, Trentham, the main contractor in a building project, engaged the defendant, Archetal, to perform certain works in relation to the project. It was common ground that Archetal undertook the works and that Trentham paid for the works. In other words, this was a case where the transaction was fully performed on both sides. And your lordships see that on page 26 of the judgment of Lord Justice Steyn, at the bottom of column 1, where he says a distinctive feature of the case is that the transactions between Trentham and Archetal were fully executed. Archetal performed the agreed work and Trentham made the agreed payments. Now, a dispute arose in connection with the works carried out by Archetal. Trentham alleged that the works were defective, but in answer to Trentham's claim for breach of contract, Archetal denied that any contract had come into existence. And the court ordered a trial of a preliminary issue as to whether there was indeed a contract. And at page 27 of his judgment, at column 1, Lord Justice Steyn set out the approach to be adopted. And your lordship see, he says, before I turn to the facts, it's important to consider briefly the approach to be adopted to the issue of contract formation in this case. And he identifies 4 matters of importance. The first is that the English law generally adopts an objective theory of contract formation. This means that in practice, the law generally ignores subjective expectations and unexpressed mental reservations of the parties. Instead, the governing criterion is the reasonable expectations of honest men. And in the present case, that means that the yardstick is the reasonable expectations of sensible businessmen. Secondly, it's true that the coincidence of offer and acceptance will, in the vast majority of cases, represent the mechanism of contract formation. It's so in the case of a contract alleged to have been made by an exchange of correspondence, but it's not necessarily so in the case of a contract alleged to have come into existence during and as a result of performance. And Lord Steyn refers there to the House of Lords and Privy Council cases of Brogden, New Zealand and Satterthwaite, and Gibson and Manchester City Council. He continues, the third matter is the impact of the fact that the transaction is executed on an executory. It is a consideration of the first importance on a number of levels. The fact that the transaction was performed on both sides will often make it unrealistic to argue that there was no intention to enter into legal relations. It will often make it difficult to submit the contract as void for vagueness or uncertainty. Specifically, the fact that the transaction is executed makes it easier to imply a term resolving any uncertainty, or alternatively, it may make it possible to treat a matter not finalised in negotiations as inessential. Now, And his fourth point, at the top of page 27, is that if a contract only comes into existence during and as a result of performance of the transaction, it will frequently be possible to hold that the contract impliedly and retrospectively covers pre-contractual performance. He refers to the well-known case of Trollope and Cole's atomic power. Now, having examined the facts of that particular case, my lords, Lord Justice Steyn made two further points of principle on page 29 of the report. And one sees this in the second column of the report on page 29. And he said in the second paragraph on the page, in a case where the transaction was fully performed, the argument that there was no evidence upon which the judge could find that a contract was proved is implausible. A contract can be concluded by conduct. He refers to the case of Brogden. And then he continues, in 1992, we ought not to yield to Victorian times in realism about the practical application of rules of contract formation. The argument that there was insufficient evidence to support a finding that a contract was concluded is wrong, but in deference to counsel's submissions, I would go further. And then he says, one must not lose sight of the commercial character of the transaction. It involved the carrying out of work on one side in return for payment by the other side, the performance by both sides being subject to agreed qualifying stipulations. In negotiations and during the performance of phase one of the work, all obstacles to the formation of a contract were removed. It's not a case where there was a continuing stipulation that a contract would only come into existence if a written agreement was concluded. Plainly, the parties intended to enter into binding contractual relations. The only question is whether they succeeded in doing so. The contemporary exchanges and the carrying out of what was agreed in those exchanges support the view there was a course of dealing which on Trenton's side created a right to performance of the work by Archetile, and on Archetale's side it created a right to be paid on an agreed basis.
Could we just go back to the
My Lord,
phrase continuing stipulation?
Yes.
What does that mean when parties spend 6 months performing a contract? How do you decide whether there's a continuing stipulation?
Well, it's not an easy matter. That word continuing stipulation is in our submission no more than a shorthand to cover a number of possible issues, such as have the parties' intentions changed in relation to let's assume there was a subject to contract stipulation. Have the parties' intentions changed? Has the parties' conduct developed in such a way that they've waived the stipulation? Have the parties performed in such a way that one side is stopped from relying on such a disclaimer of an intention to create legal relations? So the phrase continuing stipulation does in our submission hold within it the necessity of investigating the facts and the parties' performance in relation to it. So it's not a term of art. It's a term which does require the court to investigate the facts in my submission.
Yes.
If they were continuing to refuse to sign written agreements and refuse to pay any sums or to perform, then one would say readily that the negotiations were still continuing.
Yes.
But if at some point they actually perform a contract, your argument is that they've changed things.
Yes, indeed. And it's not possible in those circumstances to describe it as a continuing stipulation. Now, I accept that in one sense it's all a question of fact. How do you assess the parties' objective intentions from what they said and from what they did?
That's a question of secondary fact.
Yes.
Primary fact, so what do the parties do?
Yes.
And then you apply an objective test
That's right.
to what does the court say that they intended.
That's correct.
Now, as far as the Court of Appeal is concerned, it's more readily arguable that a Court of Appeal can interfere with findings of secondary fact than findings of primary fact.
Yes, it is. I accept that.
Yes.
Of course. But I will be coming on to submit to your lordships that in so far as this Court of Appeal purported to interfere with any finding of fact, it went wrong for a number of reasons.
I mean, you go back to, you say there was a contract, and you go back to Mr. Justice Christopher Clark's analysis of what the contract was.
Yes.
I mean, it'll be said against you that defies the reasonable expectations of commercial parties. A contract without any terms, detailed terms, on the basis of a selection of documents which deal with things like specifications is a bit unreal.
Well,
what is the actual crux point which prevents one coming to a halfway conclusion? Does it remain clause 48? Does it remain that you've got to strike out the written conditions because clause 48 is something one can't get round?
No, clause 48 is certainly in our submission something you can't get round.
Well, it is. So that it's clause 48 doesn't have. It's something you can't get round.
No, it's not something.
It's not.
No. Clause 48. Clause 48. I'm jumping ahead of myself,
Yes.
but obviously I will take your lordship's questions as you file them out.
I just want to see the shape of the argument.
No, clause 48 is as it describes itself, a counterparts clause. It is a permissive, not mandatory clause, which permits the parties to execute the contract in a number of counterparts, if they so choose. It does not require them to do so, and if they do not do so, it has nothing to say about how the parties form their contract.
But if that's right, then how do you decide what are the terms of the contract? You look at each alleged term, see whether it was in fact agreed between the parties, do you? And if it was, then so be it.
Yes.
If it wasn't, then you ask yourself the question whether in all the circumstances of the case that such a term, let's say a term which would have been agreed if there'd been a written agreement, you ask whether it was an essential term or not. Do you? Is that right? And it's easier to say it's an inessential term if the work has all been done. See Lord Steyne.
See Lord Steyne. It's easier to say it was an inessential term if the work has been done.
Which is when we come back to what may be the critical question in the case, namely whether these terms and conditions, the MF terms,
Yes.
are contractual or not.
Yes, that may be the critical question in the case.
Well, it's possibly a critical question.
It is. One of the questions which your lordships...
I mean, what your clients are trying to achieve what in this case?
The
exclusion of the terms.
Are trying to achieve the position that there was actually a contract pursuant to which they paid 1.1 million in return.
With no limitation of liability.
With no limitation of liability, save the limitation which arises under the general law. I mean,
But is that the critical question in practice between the parties,
That's
whether there's a limitation or not? That's really what the case is about.
that, in practical terms, that is what the case is about.
And
But one doesn't quite understand what your answer to the proposition is that if the parties have waived something, then it could include clause 48, and as a result, there's nothing to really preclude a court from saying that there's a contract subject to all the documents Mr. Justice Christopher Clark identified, and subject to the conditions, obviously apart from clause 48, because that's gone as that sort of boilerplate clause occasionally does go.
Yeah.
I mean, what is the answer?
Well, there are a number of issues which arise in relation to the question whether these terms and conditions were agreed.
I can see that.
They were not signed, and that is one of the reasons that Mr. Justice Christopher Clark gave for concluding that they were not incorporated into the contract. But it is not the only reason that he gave. Your lordships will see.
I mean, that's not a very compelling reason on your arguments, is it? Because you're trying to avoid all clauses.
It's not a particularly. I accept it's not a particularly compelling argument. I accept that, but it isn't the only reason that he gave. He gave other reasons. First, that when one looked at the conduct of the parties, they hadn't conducted themselves in accordance with certain of these terms and conditions. He also said, importantly, that when one came to consider what was the extent of the liability of RTS for non-performance, that the parties had not reached a concluded agreement as to what those liabilities should be.
That's the Schedule 6 point.
That's the Schedule 6 point, my lord, yes. So, and so it isn't simply a question of saying, oh, well, the judge has said there's no contract here because of this counterparts clause, which the Court of Appeal turned round against me and said was a complete answer, which in our submission it is not.
So the case boils down to the Schedule 6 point.
Well,
plus the performance.
Well, plus performance, my lord.
Plus performance.
Plus performance, because there is no challenge to the primary findings of fact of Mr. Justice Christopher Clark that in certain respects these terms and conditions were not performed.
But that's not a frightfully powerful point, because you've already said that one can step over the fact that they didn't perform in the sense of creating a written contract.
Yes.
So, I mean, they may have, in other respects, not on the face of it terribly important, like not appointing an engineer and this sort of thing, and paying in accordance with a slightly different schedule, they may have glossed that.
They may have. They may have.
But one comes back to the question whether it isn't too big a leap to say as a result you strike out the whole of the written conditions,
Well,
have a contract without any common law, which does seem quite a big leap.
Well, let's also not
Because
forget.
that's one thing nobody would have agreed, would they? I mean,
Well,
one thing that wouldn't have been agreed is the case you're advancing, isn't it?
Well,
And there may be another question of what would have been agreed or what
Yes.
was agreed,
Well,
but the idea that the parties would have agreed what you're suggesting, namely no terms, is, well, not within the, how does Lord Stane put it?
Reasonable expectations.
reasonable expectations. Well, you've also got to bear in mind, my lords, that the MF1 terms, which we're considering, were intended to be part of a tripartite contract.
Yes, with the parent.
The parent company was going to give a parent company guarantee. Now, we all know that the parent company did not give such a guarantee. And perhaps one might be entitled to say, in answer to my Lord Clerk, that it's not such a surprising conclusion to reach, that on the one hand, the limitations, the detailed limitation terms are not agreed, if on the other, the parent guarantee is also effectively not agreed, because parent company guarantee would obviously have to be given in writing in order to comply with the statute of frauds, and there would be no question about the parent company being bound by any form of waiver or estoppel in relation to that particular requirement. So it isn't just the absence of the signature, which means the clauses don't take effect as part of the contract. It's the Schedule 6 point, it's the non-performance point, and it's the important point of the third-party guarantee.
I mean, it's a slightly odd equivalence. We're prepared to go ahead without any detailed conditions because our parent company isn't going to be exposed. The inference is that we'll accept a very large liability because we can go bust and our parent company won't be exposed. It doesn't sound very commercial equivalence of factors.
But with respect, my lord, one isn't... the approach is not what is the commercial equivalence, although I accept that when one's looking at this, what inference to draw from the primary facts, one has to have some regard to what is commercially reasonable. But the ultimate question, when one is considering what was or was not agreed, is a question of fact.
Yes.
It's a question of fact at the end of the day. What did the parties agree? And the learned judge concluded, as a matter of fact, that the parties did not agree the terms and conditions because they were not, as the parties' conduct showed, essential terms. So we on the aspect of what approach does this court adopt, we invite the court to endorse the propositions of principle in Lord Justice Staines' judgment, that when the court comes to consider a case where performance has taken place, either wholly or partly, it starts from the proposition that that performance is a matter of first importance, not a matter of no importance. And when one comes to see what the Court of Appeal did in this case, in our submission, they failed properly to have regard to the performance which had taken place, and they failed to attribute to that performance the necessary weight. They, in effect, treated it as a matter of little or no importance in our submission. Now, as far as the judge's decision is concerned, my lords, it's important to keep in mind the context in which it was made, which naturally informed it. On the one hand, we had RTS running a primary case at trial, that there was a contract between it and Müller as a consequence of a letter of intent. Now, RTS's case at trial was that this letter of intent contract governed the parties' relationship throughout. and entitled it to claim the balance of the purchase price from Müller, which is why it issued proceedings against Müller, claiming the balance of the purchase price as a debt, alternatively damages for breach of contract. And this is the contract which the learned judge referred to in his judgment as the letter of intent contract. So it's important to stress that RTS's case was that it provided the goods and services pursuant to obligations under this letter of intent contract. Müller's case, by contrast, was that the letter of intent contract in fact terminated at the end of May 2005, and that another contract was subsequently formed by the parties as a result of their conduct. And that is the case that the judge accepted at trial. Now, RTS's secondary case at trial, my lords, was that if the letter of intent contract had come to an end as Müller contended, then any subsequent contract incorporated the MF1 terms which the parties had been negotiating over. Your lordships will have looked at, may have looked at the fourth draft, which was the ultimate draft of these terms. But at trial, RTS were not advancing a positive case that there was no contract if the letter of intent contract came to an end, and that positive case was advanced for the first time in the Court of Appeal. The suggestion in their printed case at paragraph 10 that such a case had been advanced at trial is not correct. In paragraph 47 and 48 of their judgment, the Court of Appeal correctly record that no such positive case had been advanced. Your lordships will find that at, as I've said, paragraphs 47 and 48 of the Court of Appeal judgment, at page 21 of the bundle. Now, the learned judge, if one turns to his judgment, approached it by looking first at the letter of intent contract. And this is at paragraphs 30 to 32, where he set out the parties' respective contentions. This is on page 43 of your lordship's bundle. And he set out the parties' respective rival contentions. And as you see from paragraph 30, RTS's submission was that the letter of intent contract incorporated its standard terms and conditions, and that it did not terminate. And you see that from the middle of the paragraph where the learned judge records, whilst the letter of intent contemplated that the contractual terms would be agreed and signed within 4 weeks, it did not provide the contract would come to an end after 4 weeks, nor should such a termination be implied. Parties made a limited provision about termination, namely that prior to the agreement on the full contractual terms, only Müller should have the right to terminate. No further provision is necessary, not least because if the agreement terminated automatically after 4 weeks, RTS would lose any entitlement to remuneration. Now, just pausing there, as I've said, their case was that the letter of intent contract applied throughout, except that it was their case that it incorporated their standard terms and conditions, a contention which the learned judge rejected on classic offer and acceptance analysis basis. But nevertheless, they were not saying there is, when the parties supplied this kit and paid £1.1 million, they were not doing so pursuant to some contractual obligation. Their contention was the letter of intent contract continued throughout. Müller's contention on the letter of intent contract, your lordships see at paragraph 31, Müller contends the letter of intent was a counter-offer to the offer contained in the quotation. That counter-offer, which was intended as a stopgap measure, did not incorporate any of the terms of the quotation, not even those that described the scope of the work. The letter of intent was simply an intimation of Müller's wish to proceed with the project as identified in the heading of the letter of intent, on the basis that if Müller terminated the project, it would reimburse RTS for the reasonable and demonstrable out-of-pocket expenses incurred by it up to the date of termination. That counter-offer was itself the subject of a further counter-offer from RTS contained in the letter of the 1st of March, which was then accepted either by Müller's conduct in allowing RTS to continue or the terms of Müller's letter of the 13th of April. Müller submits that the agreement thus constituted would expire at the end of the 4 weeks or any agreed extension of that period, and that it was implicit in that agreement, that on such expiry, Müller would have the same responsibility for the payment of expenses as it would have if it had terminated the agreement during the 4 weeks. but after the 4 weeks, RTS would not be under any obligation to continue working, and Müller would have no obligation in relation to the work performed after that date. And then the learned judge stated his conclusions at paragraph 33. In my judgment, the proper analysis of the communications between the parties is as follows. Citation J was an offer to carry out the work set in it, including RTS's standard terms. The letter of intent was a counter-offer which then responded to RTS's letter of the 1st of March, which accepted the letter of intent subject to due qualifications, and that counter-offer was accepted at the latest by Müller's letter of the 13th of April. I call that agreement thus made the letter of intent contract. So the effect of what the learned judge found there was that the letter of intent contract at least contained no standard terms and conditions because of the classical battle of defaults. He did, however, go on to find that, that Müller was correct, that the lifespan of this letter of intent contract was limited and that it did not continue to apply beyond the 27th of May 2005.
Yes. Strictly, if the judge summarises Müller's argument correctly, the letter of intent contract came to an end. There was then a period with no contract, and then there was a subsequent contract which revived the terms of the letter of intent contract. Is that how it works?
Yeah, effectively, my lord. It is true that on the learned judge's analysis, there was in theory a period during which there was no contract. I say in theory because the effect of the learned judge's determination is that the subsequent contract formed by conduct, he says by the latest, by the 29th of June, he held had retrospective effect. So, yes, one could say, standing at the 27th of May, as a result of the learned judge's determination, there is no contract. But in terms of practical effect, it has none in our submission because the learned judge went on to find that there was in fact a contract whose effect was retrospective. In other words, insofar as was necessary, covered the period between the 27th of May, when he said the letter of intent contract came to an end, and the period of the 29th of June.
Yes, I'd actually been focusing on a little earlier period, after the 4 weeks expired.
Yes, well, he
did anything for about 3 weeks.
Yes, he actually went on to hold that one way or another it didn't come to an end until the 27th of May, because it was extended either on its true interpretation or by agreement between the parties. So it actually was extended until the 27th of May. It wasn't simply a 4 week period.
Yeah, it was extended with retroactive effect. So on Müller's argument, it had come to an end after 4 weeks.
Yes.
It doesn't matter, then it matters. So, insofar as it throws some light on the general approach to continued performance.
Yes.
In conflict with prior terms.
Yes.
I thought it was extended from time to time up to the 16th of May and then re-extended until the end of May.
Your Lordship's right. That's what happened. There was correspondence which back and forth between the parties in relation to this prior to the period when it would otherwise have expanded on the initial letter. That was extended by correspondence between the parties. So the ultimate effect of the parties' communications in relation to the letter of intent contract was, as the judge held, that it expired on the 27th of May. That's true. As I say, my Lord Philip is correct. Strictly, there was a period between the end of the 27th of May and the 29th of June when there was no contract. But as I say, that is, in our submission, of no effect because of the learned judge held there was a contract which, in fact, by virtue of its retrospectivity, did cover the period between the 27th of May and the 29th of June. The effect of the learned judge's findings.
They realised it expired and then they extended
In fact, the learned judge, in the statement of facts at paragraph 35, records that someone at a meeting, I think on the 23rd of March, pointed out the letter of intent expired.
Yeah.
But then the effect of subsequent correspondence between the parties was to extend that period.
Which paragraph of the judgment is that?
That, in the statement of facts at paragraph 35, I'm looking for the judgment.
If you look at paragraph 19 of the Court of Appeal, page 10, that kind of summarises, I think, what the picture. There was a meeting, someone at the meeting pointed out the letter of intent had expired.
Paragraph 44 of the learned judge's judgment, my lord. It's the last sentence of paragraph 44.
That's it.
And then then you'll see, my lord, on paragraph 45, he records what happens thereafter. So,
It's 47, I think.
yes, that's it. That's it, my lord. Now, as far as the period after the letter of intent, the learned judge recorded the parties' respective submissions on page 56 and 57 of his judgment. And you see at paragraphs 67 and 68 the submissions that he records Müller as having made. And you see at paragraph 71 the submissions that he records RTS having made.
Why didn't that apply to the other schedules?
Why did what not apply to it?
Why, how was it that, is it simply because of clause 48 that this results?
No, it's not simply because of clause 48 in the learned judges.
Yes, and there's other points, but how was it then that you could cherry pick and have the other schedules as part of the contract?
Because clause 48 doesn't prevent that on its true construction. It's not an anti-cherry picking clause. It's simply a clause which allows the parties to exchange contracts, enter into a contract by way of counterpart. The effect of clause 48 is not as I described, an anti-cherry picking clause. The parties are at liberty to enter into any other contract on any other terms, incorporating any other of the documents which the parties have agreed. And clause 48 does not preclude that in our submission on its true construction. Now,
Then it's simply a question of fact, what they did agree.
yes, it is in our submission, and that is that proposition is soundly based in the law of contract formation in our submission. Now, the learned judge had directed himself, prior to considering the parties' respective submissions, paragraphs 65 and 66, with reference to the Trentham case. And at 65, he said, as is apparent in the above, after the letter of intent contract expired, RTS continued to build the equipment, delivered it to Müller, and were partially paid for it. In those circumstances, the court strongly inclines to concluding that the parties have entered into some contract, even though such a contract cannot be spelt out by a classic analysis of the sequence of offer and acceptance. And then he cited from the judgment of Lord Justice Steyn in the Trentham case, which I've already shown you, Lordships. And that was the framework within which he came to consider whether the parties had entered into a subsequent contract, having concluded that the letter of intent contract had a finite life. In our submission, the learned judge's approach was correct, and he did not misdirect himself, either in law or on the facts. Now, he made a number of findings of fact at paragraphs 72 to 78, having set out the parties' respective submissions. And in paragraph 72, he says, Müller's submissions are well founded. After the lapse of the letter of intent, the parties reached full agreement on the work that was to be done for the price that they had already agreed. It is, as Lord Justice Steyn contemplated, unrealistic to suppose that they did not intend to create legal relations. The natural inference is that their contract was that RTS would carry out the agreed works for the agreed price. it was not essential for them to have agreed the terms and conditions, and they did not do so. Now, he also went on to say that he declined to infer that the contract concluded between the parties included the final draft version of the conditions for the reasons which I've already mentioned to your lordships.
Go back to the first one.
My lord, yes.
The letter of intent also contemplated that the technical specifications would be in writing as well.
Yes, it did.
I'm still puzzled by how it's possible to separate the MF1 conditions from the technical specifications.
Well, in terms of one of the arguments which the Court of Appeal accepted is that contract under the terms of, as defined in the terms, meant the MF1 terms and the schedules to the contract. And the Court of Appeal said that that meant that there could be no contract on any terms which included the lesser rather than the whole. In our submission, that's a wrong interpretation of Clause 48 because it effectively elevates that clause to a subject contract.
But if that's wrong, accepting the argument that that's wrong,
yes,
some of his reasons in paragraph 73 onwards are a little curious, especially paragraph 73 and 76. Because the question is what they did agree.
yes. The question is what they
And
did.
we know that they didn't agree the contract.
Yes.
If they'd agreed the contract with all its dots and commas,
Yes.
we wouldn't be here.
No, they wouldn't.
So we know they didn't agree for clause 48, for example.
No.
And you said, you don't presumably adopt his paragraph 76, do you?
Well, all he's saying there, my lord, is this. He's observing that
Indeed, you agree it's not binding, paragraph 48.
Yeah, it's not binding.
Central to your argument that it's not
well,
binding.
it's not central to my argument, my lord, with respect, no.
But it's a significant part of the
It's
debate.
part of the argument. He is simply observing, in the normal presumption of fact, that where you have a contract.
Yes, but we know that's not this case.
Indeed.
I mean, the same is true with the same problem arises with paragraph 73, as far as I can see.
Well, 73 and 76, I accept, have to be taken together.
Right.
I agree.
So you can strike through 73 and 76, and we're back to 74 and 75.
Well,
We're back to Schedule 6 and the points we made before.
yeah,
You made
those schedule, I certainly accept that the more substantive objections to the MF1 terms forming part of the contract are the reasons that he gave in 74 and 75. All I'm saying is that he was simply observing in 76 that where one had, where it was intended, where the contract was set out in writing, the normal inference of fact would be that the parties intended that to be a written contract.
Yes, the difficulty is it proves too much
It
because contract is defined as including everything,
Yes.
And it expressly says the form of contract. This contract will include Schedule 1, which would just happen to be the conditions, but contract is everything.
Yes.
And so logically, if Clause 48 has force, it means there's nothing.
Yes. Well, another problem.
Whereas that's what the other side said.
Well, that's what they say, but it's plainly not correct.
Yeah.
In terms of because that then elevates it to effectively a subject contract clause, which it is not.
Is it not the case that what you say about clause 48 is that it doesn't have any effect, but it is to be taken as an indicator of what was likely to have been agreed between the parties?
Yes, it's simply well, there are 2 points. It's my presumption of fact that the agreement would be in writing, and that's what the learned judge took it for.
Yes, you keep calling clause 48 a counterpart clause and saying it's permissive.
Yes.
And of course it's permissive so far as the counterpart.
Yes.
Machinery is concerned, but it turns into a subject to contract clause in the latter part, doesn't it? Until each party has executed a counterpart and exchanged it with the other, the contract will not be effective. Isn't that a subject to contract?
No, it's not, my lord. And I'll address your lordship now on that issue if you wish.
Yes.
I mean, that was going to be towards the end of my submissions, but I'm happy to deal with it now.
Yes.
It simply is not a subject to contract clause. It is a counterparts clause. It does not require the parties to form this contract by way of exchange of counterparts. It has nothing to say.
If they're going to use this mechanism, then it's not going to work until they've finished.
Well,
And if it weren't there, would it make the slightest difference?
no, my lord. No, which is why, one of the reasons it's not a subject to contracts. One must not lose sight of the fact, my lords, that one of the features that clause 48 may achieve is in relation to the parent company guarantee point. Now, it's plainly important, or not simply important, but necessary, in order for RTS PLC to be on the hook, that it gives its assent in writing and becomes party to a contract in writing. But, I mean, let's assume that RTS and Müller had both signed the same draft, and for one reason or another, RTS PLC had not. So we've got a situation where RTS and Müller have expressed their assent in writing, but the PLC hasn't come on board. Now, if it was a subject contract clause, neither party could effectively waive the benefit of the parent company guarantee, because it was subject to contract until the parent company signed up. But if the effect of this is simply, but in my submission, if the parent company did not sign up, then Müller could perfectly well waive the benefit of the parent guarantee if it chose to do so.
But clause 48, in fact, is drafted as if it were a bilateral contract, because if it intended, if they had in mind the guarantor, they would have said with each of the others.
Well, it is in my submission a boilerplate clause, which is not infrequently found in contracts, but it tends, in my submission, it has its parentage in the era when we didn't have so many photocopiers, and it was, one could have a carte partie or an indenture or something like that. That's where we get these clauses from, and they don't really, in my submission, have much relevance in connection with this sort of contract. But my lordship, my Lord Clerk is right that the reasons that the main reasons that we rely on in terms of non-incorporation of MF1 are what the learned judge said in paragraphs 74 and 75 of his judgment. Because as I accepted in questioning from my Lord Collins, 73 and 76 go together. Now, if one looks at 74, one has the Schedule 6 point, that it is not correct to say that the parties had reached agreement on the remedy that Müller should have should the performance not accord with the various detailed documents which set out the performance terms. They simply hadn't agreed that. As indicated in Schedule 6, Müller was after a more ample remedy. And one cannot say from the conduct of the parties thereafter that Müller gave up that point, and indeed it is not said against me that Müller did. So that is, in our submission, a powerful reason for the learned judge to have rejected the proposition that the limitations had been accepted. The parties were still, had not agreed that. Different question as to whether those are essential terms. And I'll come on to that in due course. And then you have the observations of the learned judge that they did not proceed in accordance with some of the terms. Now, taking those points together, the learned judge was entitled in our submission on the facts to conclude that these terms had not been agreed, and it was not intended objectively that they should form part of the transaction of the contract when the parties proceeded to deliver, install, commission, and pay for the equipment. Now,
What about the price?
price now.
When was that agreed?
Well, price it was common ground that the price was agreed at trial. There was no debate at trial, but there was 1.682 million agreed. Now, my learned friend says, well, you can't identify any document in which the price is agreed. Now, my submission, that's an unrealistic approach to adopt, particularly where it is clear that in the letter of intent the parties had agreed the price. It is clear that the parties continued to proceed to pay invoices in which a percentage of the price was demanded and paid. In those circumstances, it was perfectly open to the trial judge to infer that the price had been agreed early on in the letter of intent, and that intention continued. It's not necessary in our submission for us to identify a document in which the parties say, we have agreed the price of 1.682 million. The court is entitled to infer that from the parties' conduct, and in our submission, the learned judge is entirely correct to do so. Now, I was going to show your lordships some other findings of the learned judge when he came to deal with the question of variation, because the question of variation is important and relevant because it is further conduct from which the judge was entitled to infer that the parties had the mutual intention to be bound. And your lordships will have seen that if one looks at paragraph 106 of the judgment of the learned judge at page 70, that he said that it was common ground between the parties that the contract between them was varied on the 25th of August at a meeting at RTS's premises.
Well, what contract was that?
That was the contract for the supply, delivery and installation of the equipment that the learned judge had concluded was formed no later than the 29th of June 2005. And he concluded that contract, it was common ground that that contract had been varied. RTS's contention was that the effect of the variation was that it wasn't possible for RTS to carry out fine-tuning to ensure the equipment met the specifications. Since CFAT, that's short for Customer Factory Acceptance Testing, was cancelled, it was not possible properly to test in steady-state conditions the equipment the RTS supply. As a result, it was absolved from any obligation successfully to perform the SAT testing. SAT testing is site acceptance testing. All that was necessary was the equipment provided by it remain capable of performing the throughput specified for it in the contract. So the argument which RTS was propounding was that we had an agreement which dispensed with the need to carry out customer factory acceptance testing. That meant that we couldn't properly carry out the site acceptance testing effectively. With one bound, we were free from any obligations in relation to the performance of the equipment when it was put into operation. And then the learned judge referred to various warnings which were given at the meeting on the 25th of August. And in paragraph 114, he said, Mr. Brown, that's Mr. Brown of RTS, did not, however, say anything that constituted a warning that RTS could not guarantee or warrant that the equipment supplied by it would ever satisfy the criteria laid down in the schedules, or pass the requisite tests, or that the SAT testing test could not be or would not be carried out. This is not surprising because at this stage, the thought that the RTS equipment would be capable of meeting the performance specification and assumed that SAT testing would take place at some stage. Further, as appears from paragraph 112, a plan was agreed that provided for SAT testing in the last week of October. If anything had been said to the effect the equipment might never pass the SAT test, I would expect it to have been in writing, and whether given orally or in writing, it would have rung alarm bells at Müller and would have been the subject of much discussion and report. Nothing to that effect was said, and as Mr. Brown accepted, Müller was entitled to expect that the SAT testing on both lines would be carried out. So, the importance of this evidence, as recorded by the learned judge, is that RTS were accepting that they understood that they were under some obligation in relation to the performance of the equipment. an obligation which arose in our submission under the terms of a contract as found by the learned judge. Now, it is established by House of Lords authority, and I refer to the Carmichael case, that when one is not dealing simply with a contract recorded in writing, but one is dealing with a contract which arises out of partly correspondence, partly out of oral discussions, partly out of conduct, the court, in ascertaining whether the parties have entered into a contract, are entitled to have regard to what the parties themselves thought. The subjective opinions of the parties may, as Lord Hoffman said in the Carmichael case, be some evidence as to whether there was a contract. It's not the austere doctrine, as he put it, of excluding the parties' subjective intentions does not apply in circumstances where one is not simply construing a written document. And so one sees here, importantly, in paragraph 115, the recording of the learned judge, that Mr. Brown accepted that Müller was entitled to expect RTS to carry out these acceptance tests. Now, the learned judge, therefore, as your Lordship see, concluded, rightly in our submission, that on the facts, the parties did conclude a contract. And he was right in our submission to conclude, for the reasons that he gave, that that contract did not include the terms, the MF1 terms. RTS sought permission to appeal from the Court of Appeal, and as we've said in our case, in doing so, they disavowed any challenge to any of the judge's findings of fact. And that was recorded by the Court of Appeal in paragraph 1 of the judgment of Lord Justice Waller. It's page 5 of your Lordship's appendix bundle, where Lord Justice Waller said, the appellants, RTS Flexible Systems Limited, say they are not appealing any of the judge's findings of fact. That's the third sentence in paragraph 1. So, RTS did not appeal the learned judge's rejection of RTS's primary case, letter of intent contract applied throughout, but rather, as he found, had finite life. As I've said, their case was that contract applied throughout, and it was pursuant to that contract that they delivered the equipment. They did not appeal against that. However, on the appeal, they challenged the judge's conclusion that a contract had been formed after the expiry of the letter of intent contract. And their new case was that the judge ought to have concluded that the draft MF1 terms, which the judge had concluded were not essential to the formation of the contract, were in fact essential to the formation of the contract. And it also argued that the effect of the counterparts clause, in clause 48, precluded any contract from coming into existence until agreements were signed and exchanged between the parties.
I suppose it slightly depends upon what's meant by any of the judge's findings of fact, because their alternative argument does involve rejecting, at any rate, paragraphs 74 and 75 of the judge's judgment, which are themselves findings of fact, are they not?
Their alternative argument that there was a contract on MF1 terms does, I agree, involve a challenge to those judge's findings of fact. They necessarily involve a challenge to those findings of judge's findings of fact, but as I said, their stated position in the Court of Appeal was that they were not challenging any of the judge's findings of fact. So one was left with a rather curious position where indirectly the findings are challenged, but the challenge isn't made head on to the actual findings that the judge made. In our submission, they could not be made, and such a challenge has not, in our submission, been substantiated. Now, the Court of Appeal concluded, as I said, in paragraphs 47 and 48 of their judgment, that on appeal, RTS was making a positive case for the first time that there was no contract. And one sees that from paragraph 47, where Lord Justice Waller says, as is apparent from the judge's summary of RTS's submissions, the main thrust of RTS's arguments before the judge were to argue for a continuance of the terms of the letter intent, so as to have in place a contract under which RTS continued to work, despite expiry of the period fixed by that letter. As is also apparent from the judge's judgment, the possibility of there being no contract after that period was left open, but no positive case was being made for that result by either party. Indeed, Lord Justice Staines' approach dictated the way in which the whole case was perceived. In the Court of Appeal, RTS changed their stance. They decided not to challenge the judge's ruling on the period of time for which the letter of intent applied, and the main argument they put forward was that in the result there was simply no contract concluded, and that thus any entitlement they had to receive payment was on a quantum merit. They accepted that the effect of that conclusion remained to be argued out at trial, but at worst they submitted it would limit any liability to the return of any money they had received. Their alternative submission was that if there was a contract, the judge should have held the MF1 conditions, insofar as they'd been agreed, incorporated those conditions containing a cap on their liability equivalent to the price. Now, as I said, the Court of Appeal there recorded that this was a new positive case being taken for the first time in the Court of Appeal. The exercise of reviewing the pleadings and transcripts to determine whether that was so was conducted before the Court of Appeal, and I don't propose to go through that exercise again in front of your lordships. In this regard, we submit that the Court of Appeal was correct. Now, in its printed case, RTS protests at some length that it didn't change its case in the Court of Appeal, but in so doing, it doesn't refer to this conclusion of the Court of Appeal at paragraphs 47 to 48. And it doesn't say that the Court of Appeal was mistaken when it said in paragraphs 47 and 48 that RTS had changed its stance for the first time on appeal.
Well, in paragraph 34 of the judgment of Mr. Justice Christopher Clark, the first proposition that he considers is that there was no contract at all.
Yes.
How did he come to consider that?
Yes. The way it worked was this, my lord. RTS, as I said there was a contract which applied throughout, and that contract was a letter of intent contract. They said that letter of intent contract did not expire and continued to apply throughout. Our submission was that the letter of intent contract did expire, but was replaced by a subsequent contract. And that was the contract which the learned judge found was formed as a result of conduct and which continued and which applied with retrospective effect. So yes, it is technically correct that the learned judge, that a conclusion that was open to the learned judge was that there was no contract at all. If he accepted our case on the terms of the letter of intent contract, but nevertheless rejected our case that there was no subsequent contract. But the fact is that no positive case was advanced, as the Court of Appeal says by RTS, to the effect that there was no contract which governed the parties' relations when the equipment was designed, installed, supplied, and when they made demands for payment of Müller for £1.1 million. That wasn't the positive case which we had to face. When we came to the Court of Appeal, we had to face a positive case that there was no contract founded on two pillars. The two pillars were that the MF1 terms were essential, which was not a case which was advanced at trial, and that clause 48, the counterparts clause, was a complete answer to the existence of any contract.
Now we're halfway through the morning. Is this the time that your shorthand riders would like to have their break?
That would be, I'm grateful, my lord.
Sure.
All rise.
My lords, as I mentioned, there were two grounds relied by the
Court of Appeal in order to reverse the learned judge's judgment. The first was what they effectively said he misdirected himself by focusing on Trentham rather than by having regard to the words of Mr. Justice Goff in BSc. I'm going to come to that in a moment. And then they also say that he misconstrued Clause 48, which I'm going to have a little bit more to say about in a moment. The BSc case, as I've said, is a well-known case, and it wasn't a case which either side cited to the learned judge. The Court of Appeal said, in paragraph 59 of its judgment, that the judge's conclusion that the natural inference is that their contract was that RTS would carry out the agreed work for the agreed price. It was not essential for them to have agreed the terms and conditions and did not do so, is one that, in my view, the judge would not have reached if he'd been referred to Robert Goff J's judgment and or if the no contract point had been fully developed before him. Now, the Court of Appeal don't actually explain there why it is that Lord Justice, that Mr. Justice Goff's dicta in the BSc case would have had such an impact on the judge's conclusions. We objected to this new case in paragraph...
Indeed, I mean, it's all clause 48, isn't it?
Well...
Paragraph 61. Because, I mean, they've rather laid the grounds for the middle solution in paragraph 58, where they say everything is agreed.
Yes.
MFI conditions to all intents and purposes agreed, limit of RTS's liability agreed. Now, the appellants take issue with that.
Yes.
Yes. That's their finding, and it's... we'll assume it's so. You say it's so, I think.
Well, we take issue with the fact that the question is whether liability had been finally agreed as a result of the Schedule 6 debate.
We'll have to look at that, but they
Yes.
assume the Court of Appeal is right on that.
Yes.
The only reason they give for saying that Mr. Justice Robert Goff or Lord Justice Robert Goff's dicta irrelevant is in paragraph 61.
Well, yes. And your Lordship has before that, in paragraph 60, my submission that the judge had found that these were not essential terms as a finding of fact. So I made that submission to the Court of Appeal and objected that my learned friends weren't challenging any finding of fact. Now, when one turns over to paragraph 61, your Lordship's right that the way in which this is dealt with does rather seem to tie up the question of what is or is not an essential term with the question of clause 48, and it's quite hard.
Yes, because they said that it wasn't necessary for them to consider what was strictly a finding of fact.
Yes.
And so it's all down to clause 48.
That appears to be what they're doing, but they have said that it wasn't fruitful to get into a debate about what was or was not precisely a finding of fact. And we do, with respect, find the reasoning, as I've said, in relation to this aspect of the case, somewhat opaque. Now, we submit that the Court of Appeal's reliance, for whatever it was, on Mr. Justice Robert Goff's dicta in the British Steel case can't be justified and don't support the conclusion that the Court of Appeal reached that there was simply no contract. We've dealt with the decision of Mr. Justice Robert Goff in our printed case at paragraphs 83 to 89. But in summary, we submit that these dicta that you see on page, that Lord Justice Waller refers to on page 22 at paragraph 51 of his judgment, have been taken out of context to not lay down any generally applicable principle of law, and are wrong insofar as they purport to do so.
Well, it's a case of where a fundamental term was in dispute.
Yes, my lord. It's a case where, amongst other things, no agreement had been reached on the price, as Mr. Justice Robert Goff specifically identified, an essential term of the bargain. But in order to appreciate what Mr. Justice Robert Goff was saying in this passage, I do think one has to have some regard to the context in which it was said. And the British Steel case...
But can I just pause it?
Yes.
Isn't the Court of Appeal's deployment of Mr. Justice Robert Goff's statement absolutely fine as far as it goes? Because what the Court of Appeal was saying was, and it may be that what they were saying was simply that Mr. Justice Robert Goff is cautioning against the court finding contracts which parties would never have entered into. The parties would never have entered into here a contract without conditions, and therefore Mr. Justice Christopher Clark's judgment must be wrong. And as far as it goes, there's a lot of force in that, isn't there?
As far as it goes, my lord, yes. That may be what the Court of Appeal is saying. But the problem with it is that here we are in the Court of Appeal, facing an appeal where no challenge is being made to the judge's findings of fact. And indeed, I make the point to the Court of Appeal that it was not said below that any of these MF1 terms were essential terms. We then face a challenge in the Court of Appeal to the proposition that they were, in fact, essential terms, and the Court of Appeal rely on the dicta of of Mr. Justice Robert Goff. And it isn't clear for what purpose they're doing that, because if they don't establish any principle of law, then they don't, with respect, lead to any conclusion in relation to the facts of the present case. And they don't lead to the conclusion that if they had been cited to Mr. Justice Christopher Clark, that they would have had any impact on him. But if they're being put forward as a proposition of law, one has to see the context in which this statement was made. And the context in which the statement was made is, in our submission, a regrettable lapse on the part of Mr. Justice Robert Goff in relation to what are the obligations which can arise under a unilateral contract.
Yes, could I suggest a slightly different interpretation from that put forward by my lord? Because paragraph 58 rather suggests that they didn't really agree with the judge, what the judge said about the MF1 terms, because they asserted that they had, to all intents and purposes, been agreed, which was the opposite of what Mr. Justice Christopher Clark said. And on that basis, as far as I can see, the basis upon which what they were applying Mr. Justice Robert Goff's dicta to the condition 48. And that was the point which remained to be, that was an essential part of their bargain. And so it was that they said that it was Justice Robert Goff's analysis applied. Now, I quite understand you say that's all wrong.
It is entirely wrong, my lord.
Whether it proves enough for you, I'm not sure.
Well, it may be that one has to take it in stages, and I would respectfully invite your lordships to consider what it was that Justice Robert Goff said in the context, and then to consider whether it has any application outside the context in which it was said. Because the British Steel case was a case where British Steel manufactured and delivered 139, I think it was, steel nodes at the request of Cleveland Bridge. Now, they did that in response to a letter of intent. And British Steel delivered all the nodes, but Cleveland Bridge complained that the nodes had been delivered late and out of sequence. And British Steel sued Cleveland Bridge for the contract price or for a quantum merit. Cleveland Bridge counterclaimed for damages for breach of contract for the failure of British Steel to deliver the nodes in time and in sequence. So it's important to appreciate that in the British Steel case, it was essential to Cleveland Bridge's case to establish that there was a contract which contained a particular delivery term. So the only basis on which Cleveland Bridge in the British Steel case could succeed in its counterclaim for damages was to establish that there was a contract which contained a delivery term. If I can take your lordships to that case, it's at Authorities Bundle 1, tab 4. And if one looks at the first paragraph in the judgment of Mr. Justice Robert Goff, between letters C and D at page 506, you will see that, as I've said, that BSC counterclaimed on the ground that BSC had, in breach of contract, delivered the nodes too late and out of sequence. If one goes down to subparagraph F on that page, the learned judge turns to the facts of the case and he says this is a case in which there's no doubt that BSC did in fact manufacture the 137 cast steel nodes in question, requested CBE, and did deliver them to CBE, but despite protracted negotiations between the parties, no formal contract was ever entered into between them. CBE complained that BSC were late in delivering the nodes, and that the cause of the delay were, with one minor exception, all within the control of BSC. They also complained that BSC failed to deliver the nodes in the sequence requested by CBE. In these circumstances, two main areas of dispute developed between the parties. First, was there any binding contract between the parties at all under which the nodes were to be delivered? CBE contended there was such a contract, which is to be found in certain documents, including the letter of intent, and the conduct of BSC in proceeding with the manufacture of the nodes. Now, it's important that one notes there that BSC's contract mechanism allegation in this case was that it had issued a letter of intent, and by proceeding with the manufacture of the nodes, a contract had come into existence. And it's obvious, as I've said to your lordships, why it was necessary for BSC to establish, for CBE to establish that a contract had been formed as a result of BSC starting to perform, because that's the only way in which they could get a term which would protect them in relation to the claim for delivery out of time or out of sequence. So he also found as a fact, on page 108 of his judgment, subparagraph C, that BSC would not have agreed to the ICE conditions of contract, which provided for unlimited liability for consequential loss arising from late delivery. That was a finding of fact that the learned judge made there. And that informs, we submit, what the learned judge came to say later on in his judgment. His legal analysis begins at page 509, paragraph G, where he says the question whether in a case such as the present any contract has come into existence must depend upon a true construction of the relevant communications which have passed between the parties, and the effect of, if any, of their actions pursuant to those communications. There can be no hard and fast answer to the question whether a letter of intent will give rise to a binding agreement. Everything must depend on the circumstances of the particular case. In most cases where work is done pursuant to a request containing the letter of intent, it will not matter whether a contract did or did not come into existence, because if the party who's acted on the request has simply claimed payment, this claim will usually be based on a quantum merit, and it will make no difference whether that claim is contractual or quasi-contractual. Of course, a quantum merit straddles the boundaries of what we now call contract and restitution, so the mere framing of a claim as a quantum merit claim or a claim for a reasonable sum does not assist in classifying the claim as contractual or quasi-contractual. But whereas here one party is seeking to claim damages of breach of contract, the question whether any contract came into existence is of crucial importance. He then continues, as a matter of analysis, the contract, if any, which may come into existence following a letter of intent, may take one of two forms. Either there may be an ordinary executory contract under which each party assumes reciprocal obligations to the other, or there may be sometimes what is called an if contract, i.e. a contract under which A requests B to carry out certain performance and promises B that if he does so, he will receive a certain promise in return, usually remuneration for his performance. The latter transaction is really no more than a standing offer which, if acted on before it lapses or is lawfully withdrawn, will result in a binding contract. And in the next paragraph, my lords, B to F, Mr. Justice Goff considers whether on the facts of that case there was a binding executory contract. And you'll see that he says, that's just below C, in these circumstances, it's very difficult to see how BSC, by starting work, bound themselves to any contractual performance. No doubt it was envisaged by CBE at the time they sent the letter that negotiations had reached an advanced stage and that a formal contract would soon be signed. But since the parties were still in a state of negotiation, it's impossible to say with any degree of certainty what the material terms of that contract would be. I find myself quite unable to conclude that by starting work in these circumstances, BSC bound themselves to complete the work. And then he says he put it to counsel whether BSC were free at any time after starting work to cease work. His submission that they were not free to do so, even if negotiations and the terms of the formal contract broke down completely. I find this submission to be so repugnant to common sense and commercial realities I'm unable to accept it. Perhaps revealing on the 4th of April 1979, BSC did indeed state they were not prepared to proceed with the contract until they had agreed specification. A reaction which, in my judgment, reflected not only the commercial but also the legal realities of the situation. And then he therefore rejected, he says, CBE's submission that a binding executory contract came into existence in this case. He continued, there remains the question whether by reason of BSC carrying out work pursuant to the request contained in CBE's letter of intent that came into existence, contract by virtue of which BSC were entitled to claim reasonable remuneration, i.e. whether there was an if contract of the kind I have described. And he says, in the course of argument I was attracted to this alternative really on the basis that not only was it analytically possible, but also it could provide a vehicle for certain contractual obligations of BSC concerning their performance, e.g. implied terms as to the quality of goods supplied by them. But the more I've considered this case, the less attractive I have found this alternative. The real difficulty is to be found in the factual matrix of the transaction, and in particular the fact that work was being done pending a formal subcontract, the terms of which were still in a state of negotiation. And then he refers to the notorious fact that when a contract is made for the supply of goods on a scale and circumstance such as the present, it will in all probability be subject to standard terms, usually the standard terms of the supplier. Such standard terms will frequently legislate not only for the liability of the seller for defects, but also for the damages for which the seller will be liable in the event not only of defects in the goods, but also of late delivery. It's commonplace that a seller of goods may exclude liability for consequential loss and may agree liquidated damages for delay. In the present case, an unresolved dispute broke out between the parties on the question whether CBE's or BSC standard terms were to apply, the former providing no limit to the seller's liability for delay and the latter excluding such liability altogether. Accordingly, when in a case such as the present, the parties are still in a state of negotiation, it's impossible to predicate what liability, if any, will be assumed by the seller for defective goods or late delivery if a formal contract should be entered into. In these circumstances, if the buyer asks the seller to commence work pending the parties entering into a formal contract, it's difficult to infer from the buyer acting on that request, yes, acting on that request that he is assuming any responsibility for his performance, except such responsibility as will rest on him under the terms of the contract, which both parties confidently anticipate they will shortly enter into.
What does that mean? Is he assuming any legal responsibility at all, or is Mr. Justice Goff simply saying that he anticipates he will be entering into some responsibility when the terms are concluded?
Well, the problem with this analysis, my lord, is this, that as we have seen, this passage follows on from his rejection of the executory contract analysis, and he is examining the if contract, the unilateral contract, as a mechanism in relation to the circumstances of this case. So what he's saying here is not directed to the executory contract analysis, which he has already rejected. So it's directed towards the unilateral analysis, and the problem with it is that there is an assumption, which in our submission is heretical, that under a unilateral contract, the offeree assumes any obligations. And one sees that from paragraph G of the report at 510, where he says he was attracted to the alternative of the if contract on the basis it was analytically possible, but it could provide a vehicle for certain contractual obligations of BSC concerning their performance. Now, if it truly is, by definition, a unilateral contract and not an executory contract, it could not provide the vehicle for any obligations, because by definition the offeree assumes no obligations at all to the promisor. And one gets further flavour of that when one reads on in this judgment below J, where he says, because he says the parties are in a state of negotiation, it's not possible to predicate what liability will be assumed. He then goes on to say, in these circumstances, if the buyer asks the seller to commence work pending the parties entering into a formal contract, it's difficult to infer from the seller acting on that request any responsibility for that performance. But in the unilateral contract analysis, which is what he's concerned with here, the seller or the buyer, respectively, whichever is the offeree, is in fact assuming no responsibility at all.
Is that right? I mean,
Yes.
If in this case Cleveland Bridge said to British Steel, if you supply, we'll pay you, well, it may be difficult to see how British Steel are undertaking any liability for delay, because it's if you supply, if and when, presumably.
Yes.
But I wouldn't have thought there was much difficulty in seeing how British Steel might, at common law, by implication, undertake a liability for quality. And that's obviously one of the two things which worried Mr. Justice Robert Goff.
Yes.
He's concerned with liability for late delivery and liability for defective goods.
If as your lordship posits, there is any liability in relation to quality, by definition, it becomes a bilateral or synalagmatic contract and not a unilateral contract.
I'm not sure. You can have a choice whether to supply. If you supply me the nodes, then I'll pay you. The law surely implies into the contract, if it comes into existence, and it's a matter of British Steel's choice whether it does, that the nodes will be of good quality. That just arises by implication of law.
Well, it can only arise by implication of law if the law treats the offeree in this scenario as making a promise into which this implication of law may be implied. If the law does not treat the offeree as making a promise, no such implication can arise.
But why wouldn't it?
Well,
Why wouldn't the law imply just such an obligation?
yes, this is the difficulty of the analysis in this case. It has been criticised. The result of no contract has been criticised by, amongst others, Professor Attia, and I'm going to show you, Lordship.
But the judge here is not, he doesn't separately relate to the quality, refer to the quality point, does he?
I think he does.
In his earlier analysis.
Defective goods, he does refer to it at H, not only of defects in the goods, but also late delivery, and then there's a reference to consequential loss, and then below J, defective goods or late delivery.
Yes.
And I take your point about the late delivery, that is puzzling. Even Homer nods occasionally.
But this is very far removed from this case, where the letter of intent was explicit.
Yes, it is very far removed. All I'm seeking to show your lordships is if one is going to proceed on the basis that what was said here was some form of principle which the learned judge did not have regard to as a matter of law, then one has to examine whether the principle in which the context in which this dictum arose was legally sound. And all I'm saying to your lordships is that, with regret, that when Mr. Justice Goff said what he said in the BSc case, in the context of a unilateral contract analysis, he was mistaken. So when he says, and this is the paragraph, the passage which was cited by the judge, it would be an extraordinary result if the parties assumed liability which they wouldn't otherwise have assumed. In fact, it is a legal impossibility that any such liability would have assumed under a unilateral contract. Because under a unilateral contract, contract is a promise for an act, not a promise for a promise, as Lord Millick put it in the Starson case, dealing with Himalaya clauses. It's a promise for an act, not a promise for a promise. There's no counter-promise in the unilateral contract analysis. So when one sees what Mr.
I
Justice.
think we got the point, and I find it very difficult to agree.
Well,
it seems to me that all you're getting, if you, in the unusual situation where someone makes a unilateral offer to you, is a right not to perform. That says nothing about the quality of the performance. If you delivered a bomb instead of some nodes, I would have thought you would be responsible in contract as well as in tort.
You'd certainly be liable in tort.
I'm supposing they said, look, we're in desperate straits, we want you to deliver the nodes, but we fully appreciate we can't expect you to undertake the obligation, but if you deliver them, we'll pay X. And British Steel respond to that and they deliver something. Surely they've got to deliver the something which is the quid pro quo for the X. They can't just deliver any old rotten goods.
Well, there are 2 points. If it is a strict unilateral contract analysis, then the offeror, the promisor, only has to pay if the promisee complies with the request.
You just say it's a shortfall, so nothing's due.
Yes.
Yes.
If any old goods were supplied, then there would be no obligation to pay. There would have to be compliance with the request. So if the classic unilateral contract analysis is paying someone to go to York.
What about if defective goods were?
I mean, as long as they're described as nodes, it's all right. It doesn't matter how they only last 6 months.
It depends on the construction.
Why wouldn't one imply a term to make the contract work? That the nodes had to be both nodes and workable nodes.
Well, because that involves, with respect, my lord, the proposition that under a unilateral contract, a promise is made by the promisee. Promisee makes no promises. He simply, he either performs...
That's the question.
Well,
I mean, that argument assumes the answer.
Well, I'm going to show you, my lord, the authorities which establish this.
Does it matter here at all?
Well,
Yes.
well, it only matters, this unilateral contract analysis only matters if, as I've said, the Court of Appeal were right that the dicta of Mr. Justice Goff establish any principle of law, which, for some reason, the learned trial judge was wrong to ignore. If they do, then it is necessary to conduct this analysis.
You could possibly said this is a unilateral contract.
No, you couldn't possibly say this was a unilateral contract, I agree. But then one asks oneself, why is it that the Court of Appeal has said that a dictum in the contract, a dictum which is based on flawed analysis in relation to a unilateral contract, has any relevance at all to what was discussed?
Well, we'll never know unless Lord Justice Waller comes and tells us what he meant by paragraph 56.
Yes.
But anyway, now the Court of Appeal, more difficult, can possibly be bound by a first instance decision. The question is whether a principle enunciated at first instance is a good principle or a bad principle.
Indeed.
Looking at the facts to see on what basis the judge at first instance made the statement he did isn't really very helpful.
Well,
Is it?
With respect, my lord, what the Court of Appeal said was an extraordinary result was, in fact, what Mr. Justice Robert Goff said was an extraordinary result in the British Steel case was, in fact, a legal impossibility. It was a legal impossibility because the analysis he was conducting was in relation to a unilateral contract, and under a unilateral contract, the promisee makes no promises. I mean, I can show you, Lordships.
The basic proposition which Mr. Justice Robert Goff was enunciating, forget about the context, has some sense, doesn't it? I mean, you don't, basically he was saying that you don't find contracts which in reality parties would never have entered into. Well, I would have thought we all agreed with that. Well, and it's a difficulty is it's a point to some extent against your primary case.
Well, the problem with that, if it is not a general, if it's not a principle of law, which is being
principle of common sense,
principle of common sense, then that principle of common sense has to be informed by the facts of the case. It's a factual analysis.
Yes.
What effectively is being said is that we're not challenging any of the judge's findings of fact. That's the basis on which the appeal was mounted. Lord Justice Waller says that, well, the judge ought to have had regard to what Mr. Justice Robert Goff said, but that reflects a challenge to the facts as found by the learned judge, namely that these terms were or were not essential. So if all that this dictum is being deployed for is a proposition of common sense, then one doesn't need Mr. Justice Robert Goff's dictum at all. And one simply has to say, did the judge get it right or wrong as a matter of fact? But in order to ascertain whether the judge got it right or wrong as a matter of fact, one has to burrow down a little bit more deeply and inquire whether the terms which he found were not agreed were essential or not to the conclusion of the bargain. No such case was made at trial, and that is a proposition of fact to be established at trial, whether these terms were or were not essential. So either Goff is setting down some principle which the judge was wrong to follow, some principle of law, which in our submission is not, or it's some question of fact. But if it's some question,
you say it's a matter to be found at trial, but it's not a matter which could be found by reference to the parties' subjective intentions.
Well,
and I don't see Mr. Justice Christopher Clark as having used the word essential in that sense. Contract is an objective matter, and he expressed a robust objective view about whether it was realistic to suppose there was no contract.
Yes.
He then went on and said it was not essential for them to have agreed the terms and conditions. That seems to me a proposition of law, actually. It's true. It's not essential to agree terms and conditions in order to have a contract. The law will supply many things. But as to whether objectively it's sensible to treat the parties to have contracted solely by reference to the documents he identified, it seems to me that's a question of analysis. I don't think it's really a question of, certainly not a question of pure fact, it's a question of legal analysis, isn't it?
Well, it's not simply, with respect, my lord, a question of legal analysis. It is a question of fact. Because, as we know, in the memorable phrase of Mrs. Justice Bingham, as he then was, the parties are masters of their contractual fate. And what he meant by that in the context of the Pagnan case, which I may show you, Lordships, is that it is a matter for the parties to determine what is or is not essential to their bargain. Now, my Lord Mance is absolutely right. When the court comes to perform that analysis, it is concerned to ascertain what the parties' objective intentions are. The parties' objective intentions as expressed in their communications and in their conduct. But it is not possible, save in very defined circumstances, to say that certain terms are essential. Obviously, there are certain terms without which you can't have a bargain. And leave aside, for example, the implication of terms as to price, the Sale of Goods Act might provide. One might say that the price of equipment was an essential term, and if the parties haven't agreed that, the court might say, in those circumstances, that an essential term, which is not simply essential in fact, but essential in law, has not been agreed. But at trial, there was no suggestion that these MF1 terms were essential to the conclusion of any bargain. It wasn't the case that we were facing at trial. So we didn't have to investigate whether, as a matter of fact, these terms were essential or not. That simply wasn't either party's case. Our case was that they were not incorporated. It therefore follows that they were not essential. RTS's case was that their primary case, and in any event, was that there was a contract on the letter of intent terms, which continued throughout. It follows by implication that the detailed MF1 terms were not part of that contract either. It is true that their secondary case was that if the letter of intent contract came to an end and was replaced, then it was replaced by a contract which contained the MF1 terms. But that wasn't being put forward on the basis that without these terms being agreed, there could not be a contract. because these terms were essential to the conclusion of a bargain. That wasn't the case. Now, leaving aside the question as to whether certain terms are essential as a matter of law, it is not, in my submission, the law that limitations of liability are essential in law. They may be essential in fact, if that is what the intentions of the parties are objectively construed from their communications. But, as I said, the essentiality of these terms was not an issue, as a fact, was not an issue which was explored at trial, because neither side was suggesting that they were essential to the conclusion of the bargain. Yes, and we do submit that on that basis, when it is not an issue at trial, whether limitations are, as a matter of fact, essential to the conclusion of a bargain, that isn't a conclusion that the Court of Appeal can reach on its own motion, simply by saying, as a matter of common sense, if that is what they were saying, some limitation of liability was essential. That is not a matter which can be taken for the first time in our submission in the Court of Appeal. It requires an examination of the facts at trial, and those facts were not explored or were not fully explored because neither side was contending that these terms were essential to the conclusion of a bargain. Now, I was going to refer your lordships to the decision in Pagnan, which is no doubt very familiar to your lordships, but I would just like to show your lordship what was said in that case.
And what proposition is this?
This is the proposition that the parties are masters of their contractual fate, and it's a matter of fact, at the end of the day, whether terms are or are not essential. Matter of fact, based on the parties' objective intentions. You cannot say, without investigating the facts, whether a term is or is not essential, unless it's one of those terms which falls into the context of...
And why would it be relevant whether they were essential?
Because that is the conclusion that the Court of Appeal reached, that they were essential to the conclusion of a bargain between these parties, and that because they had not been agreed, there could be no contract. That is the alternative basis on which the Court of Appeal reversed Mr. Justice Christopher Clark. They said that if he'd had regard to what Mr. Justice Robert Goff said, Mr. Justice Christopher Clark would not have reached the conclusion that these terms were not essential to a bargain. And they would have concluded effectively that they were essential. If one looks at paragraph 59 of the judgment of the Court of Appeal, at page 24, it is said, the judge's conclusion that the natural inference is that their contract was that RTS would carry out the agreed work for the agreed price. It was not essential for them to have carried out the terms and conditions, and they did not do so, is one that, in my view, the judge would not have reached if he'd been referred to Robert Goff's judgment, and or if the no contract point had been fully developed before. So it is, in our submission, the Court of Appeal saying that these terms were essential. Now, they can either be essential as a matter of law, or they can be essential as a matter of fact. We are, I believe, agreed, although it may not be common ground, that terms of limitation are not essential to the conclusion of a contract, as a matter of law. Whether they are essential as a matter of fact depends on an analysis of what the parties said and did, and whether one draws the objective inference from that evidence as to whether those terms were or were not essential. Now, that is an analysis in our submission which can only be conducted at trial, not for the first time in the Court of Appeal, as the Court of Appeal sought to do in this case. So, the Pagland case, which I was going to take the Lordships to, at volume 2 of the authorities, tab 24, is a decision of, first instance, of Mr. Justice Bingham, as he then was, and then Lord Justice O'Connor, Lord Justice Lloyd, and Lord Justice Stocker. And it was a case concerned with the formation of a contract for animal feed products. And the curiosity of the case was that the contract was effectively formed as a result of communications not by the parties between themselves, but by the parties with an intermediary. So it wasn't the classic analysis of offer and acceptance. It may be that if the parties had not communicated through the intermediary, the Court of Appeal may have reached a different conclusion, or may have reached the conclusion that the contract was formed at a different period in time. But the statement of the law in the judgment of Mr. Justice Bingham appears at 610 of the judgment in the second column under the heading of the law. And this is a contract which arises out of correspondence, not out of conduct, but nevertheless, he says the general principles to be applied in deciding the issue in this case are not, I think, open to much doubt. The court's task is to review what the parties said and did, and from that material to infer whether the parties' objective intentions as expressed to each other are to enter into a mutually binding contract. The court is not, of course, concerned with what the parties may subjectively have intended, the point my Lord Mance made. As Lord Denning put it in Storer, in contracts you do not look into the actual intent in a man's mind, you look at what he said and did. Contract is formed when there is, to all outward appearances, a contract. A man can get out of a contract by saying, I did not intend to contract, if by his words he has done so. His intention is to be found only in the outward expression which his letters convey. They show a concluded contract, that is enough. And then he says, it's furthermore clear that where exchanges between parties have continued over a period, the court must consider all these exchanges in context, not seize upon one episode in isolation, in order to conclude that a contract has been made. There will be some cases where continued negotiations after a contract has allegedly been made will lead to the inference that the parties never in truth intended to bind themselves, hussy and pawn pain. This will more obviously be so where a term raised by one other party early in the negotiations had not been the subject of agreement at the time of the alleged contract. And instead is an example of such a case. There, although the parties had agreed there should be a strike and lockout clause, they'd never agreed to what the terms of the clause would be. But the parties have not reached agreement on terms which they regard as essential to a binding agreement. It naturally follows there can be no binding agreement until they agree on those terms. But just as it's open to the parties by their words and conduct to make clear that they do not intend to be bound until certain terms are agreed, even if those terms objectively reviewed are of relatively minor significance, the converse is also true. The parties may by their words and conduct make clear that they do not intend to be bound, even though there are other terms yet to be agreed, even terms which may often or usually be agreed before a binding contract is made. And reference is made to the case of Love and Stewart. And then at the bottom of the page, Mr. Justice Bingham continues, the parties are to be regarded as masters of their contractual fate. It's their intentions which matter, and to which the court must strive to give effect. In this endeavour, help is to be gained from the observation of Lord Denning and Port Sudan and Chettiar. Considering this question, I do not much like the analysis in the textbooks of inquiring whether there was an offer and acceptance or a counter-offer and so forth. I prefer to examine the whole of the documents in the case and to decide from them whether the parties did reach an agreement upon all material terms. In such circumstances, the proper inference is that they agreed to be bound by those terms from that time onwards. That is the result of Brogden. I think, furthermore, that the court must bear constantly in mind the subject matter with which it's dealing. The relevant principles of law of contract are, no doubt, of universal application. But the proper inference to draw may differ widely according to the facts of the case. One case may concern a protracted negotiation, perhaps conducted in writing through lawyers between the parties who have had no dealings of any kind before. Another may concern a series of quick-fire exchanges between professionals, both of them practitioners of the same trade, both having had many years' previous dealings with a wide measure of common experience, knowledge, language, and understanding between them. One could not sensibly approach these cases in the same way. Inferences which it would be appropriate to draw in one case might be quite inappropriate in the other, but the Court of Appeal's task remains essentially the same, to discern and give effect to the objective intentions of the parties. Now, while we're on the subject of what is or is not essential, it's important to have regard to what Lord Justice Lloyd said in the judgment of the Court of Appeal. And at page 619, he refers to...
Is this essential as a matter of fact or essential as a matter of law?
Essential as a matter of fact. And we're just coming on to that.
So this simply says there's no binding agreement if the parties don't agree a term which they regard as essential.
Yes.
That's all it is.
That's all it says, my lord. But what it also says is that it may appear that it is a very unimportant term to the court. But if the parties regard it as essential, there we are. It may appear that it's a very important term to the court. But if the parties don't think it's essential, there we are.
And the court has to decide what the parties thought by looking at what they said and did,
Yes.
to see what objective conclusion they can reach.
Your lordship is entirely correct in that.
And if there's a clause that appears utterly insignificant to the court and there's nothing in the correspondence that suggests that the parties took a different view,
Yes.
then the court can conclude that the parties obviously shared the reaction of the court.
Yes.
Yeah.
Yes, absolutely. But it does not follow that if the parties regard something which would objectively perhaps appear to be trivial, if the parties objectively regard that as very important, then they, as masters of their contractual fate, are entitled to treat that as an essential matter, and the court will give effect to that.
And whether they did or not is a question for the court to decide in all the circumstances.
It is, and it's a question of fact.
But does one also have to consider the implication of that particular clause on those terms that the parties plainly were ad idem on? And only say, well, there's no contract.
Yes.
If the implications of the clause that was not agreed have significant impact on the clauses that were.
Yes, one would, in my respectful submission, be entitled to have regard to that, because that is evidence of the parties' contract.
So the judge's approach was essentially correct, was it? Namely that the judge decided that there was a binding agreement between the parties. When he came to decide what the terms were, he looked to see what terms were agreed, and he set out the terms he thought were agreed and treated them as parties to the contract, as part of the contract. He then identified some matters which weren't agreed, which might have been agreed if the thing had gone to the bitter end, the contractual negotiations, but unless they were essential terms, then he was quite entitled to hold that there was a binding contract on the terms he found.
Yes, that's exactly correct.
And when one comes to the Court of Appeal, the analysis is, the parties would never have agreed to be bound by the terms on which they were agreed if they hadn't also got agreement to the terms on which they were not agreed.
Well,
They would, in those circumstances, have said, no, all the terms we have agreed go by the board, we just proceed on quantum merit or whatever.
yes, well, that's what the Court of Appeal did. In our submission, they were incorrect to do that, because it's not a proper way of approaching the task. With respect, if one is going to investigate whether terms are not essential, one conducts that investigation at the trial. One does not conduct that investigation de novo in the Court of Appeal when all the evidence which is relevant to that question has not been elicited at trial. And as I said to your lordships, there's no question that at trial neither party was asserting that these MF1 terms were essential terms, without which there could not be a concluded bargain. That was not what the parties were saying. And it's certainly not the way in which cross-examination, for example, of RTS's witnesses was conducted by me.
So that's why the judge didn't consider whether Schedule 6 was essential.
Yes.
The RTS were saying that any contract was on some terms, primarily on their own, alternatively.
Yes. RTS was saying there's a letter of intent contract which incorporates our standard terms and conditions, which applies throughout. That was their primary case. So we designed, delivered, installed, manufactured, and supplied all of this kit, and set it up and got it running at your premises and asked for £1.1 million because the letter of intent contract applied throughout. And by the way, the letter of intent contract incorporated our standard terms and conditions.
And in your case?
Excuse me, my lord. Our case was that whatever contract was formed initially didn't incorporate your standard terms and conditions by process of the offer and acceptance analysis. So whatever initial contract was formed did not contain those standard terms and conditions by reason of offer, counter-offer rejection. The judge accepted that was correct. He also accepted that it was correct that whether as a process of construction of the letter of intent or by subsequent agreement of the parties, the letter of intent contract expired on the 27th of May 2005. Our case thereafter was that by their conduct the parties had entered into a contract under which RTS undertook to deliver certain items of equipment, but it did not include the MF1 terms, which, as I said, neither party was contending was essential for the reasons which the learned judge identified in his judgment, and for the additional reason that it was a tripartite arrangement which was never signed by the guarantor.
But they were saying the MF1 terms were agreed.
They were certainly saying that the MF1 terms
So that's live.
were
The question is
incorporated.
whether the judge held they weren't agreed, and it's open to us to hold that they were agreed,
Well,
because that was a very issue being debated before the judge. And so that's one point we'll have to grapple with. Assuming you're right on your primary case. But of course the primary case isn't the real point, is it? The real point is whether the MF terms are... That was what the case is really about. But it's open, that point is live, isn't it?
Well-
it's live now, it was live at the trial, and it's live now.
yes.
And so if we decide that the MF terms were agreed, then they were agreed.
Yes, but with respect, that involves a number of leaps over a number of
Well, that's
hurdles,
true. I would obviously
which-
have to think about why they were,
we
whether
say-
the judge was right, and we'll have to consider all that. But it's certainly open.
Yes, I would seek to persuade your lordships that.
Well, I understand that.
On facts, there is not.
Yeah.
But your law. Well, I'm facing a case where I've lost in the Court of Appeal on the basis of seeking notice.
I follow that, yeah.
So that's why I've been directing my fire towards that particular case. Your lordship.
I mean, I quite understand your point that whatever else would have happened, nobody would have reached the decision, a contract on the terms the Court of Appeal said.
Yes.
Namely, no contract, or no terms at all.
And indeed, as my Lord Phillips pointed out earlier in the course of the argument, it appears that the Court of Appeal inched towards that conclusion and then yet decided not to, for a reason which is not entirely easy to discern. But there we are. That's my learned friend's alternative case. But I just wanted to show you, just by way of sweep up, what Lord Justice Lloyd said. I mean, essentially,
Yes.
In Pagnan, at page 619, first column, he starts, as to the law, there's about halfway, third of the way down the page, as to principles to be derived from the authorities, some of which I've already mentioned, can be summarised as follows. And then he summarises the principles, but the one I really draw your lordship's attention to is subparagraph 6 on page 619, second column. It sometimes said that the parties must agree on the essential terms and that it's only matters of detail which can be left over. This may be misleading since the word essential in that context is ambiguous. If by essential one means a term without which the contract cannot be enforced, then the statement is true. The law cannot enforce an incomplete contract. If by essential one means a term which the parties have agreed to be essential for the formation of a binding contract, then the statement is tautologous. If by essential one means only a term which the court regards as important, as opposed to a term which the court regards as less important or a matter of detail, the statement is untrue. It is for the parties to decide whether they wish to be bound, and if so, by what terms, whether important or unimportant. It is the parties who are, in the memorable phrase coined by the judge, masters of their contractual fate. Of course, the more important the term, the less likely it is the parties will have left it for future decision. But there is no legal obstacle which stands in the way of parties agreeing to be bound now, while deferring important matters to be agreed later. It happens every day when parties enter into so-called heads of agreement. Mr. Rokinson's a special case, I do not think so. Mr. Rokinson relied heavily on the fact the judge described the terms on which the parties had not yet agreed as terms of economic significance to these bouts. If I'm right in the propositions I've stated, in particular 4 to 6, the fact that the terms yet to be agreed were of economic significance would not prevent a contract coming into existence forthwith if that's what the parties intended. So I find no error of law in the judge's approach. So, what is or is not essential is a matter for the parties, not for the court. And as your lordships have rightly said, at the end of the day, the court's got to look at what the parties said and did and infer from that objectively what their intentions, mutual intentions towards one another were. Now, the court, in the context of this case, which was an exchange of correspondence, the court rightly said it's the subjective intentions of the parties don't matter. It's the objective intentions. There is, or maybe a slight gloss on that to be derived from what Lord Hoffman said in the Carmichael case, because in that case, the question was whether a contract had been formed as a result of correspondence and conduct. And Lord Hoffman said that what the parties thought they were doing, i.e. subjectively thought they were doing, might be some evidence that there was a contract in that case. Perhaps I should show you, Lordships, what Lord Hoffman said there. I only raise this because, I mean, it wouldn't be right for me to say, on the state of the authorities, subjective views of the parties is entirely irrelevant. It may have some relevance in showing what the parties...
This is all a very dodgy area. Very dodgy area.
Well...
if the court thinks what the parties subjectively were thinking was a reasonable thing to think subjectively...
Yes.
A reasonable inference is that across the line between the parties.
Well, it may be
Yes.
that it is quite difficult to draw the line. But what is or is not.
One has got to be terribly careful in not applying to an executed contract.
Yes.
Principles of law enunciated in the context of an executory contract.
Yes.
Isn't the reality this? If the parties have actually performed the whole contract, the first question to look at is, well, what terms of this contract had they agreed between them? Like price, rather important. Had they agreed the price?
Yes.
Yes. Had they agreed the timetable? Yes. And then you identify some terms they hadn't agreed.
Yes.
And then you ask yourself the question, objectively, were the terms they had agreed subject to the condition precedent that they agreed the terms they hadn't agreed? Yes. And if the answer to that is no, the thing can stand and parties objectively intended that it should, notwithstanding they still had some things to sort out, then you apply those terms.
Yes.
If you reach the other conclusion, then you say the whole thing's off. You have to see what common law says about the consequences of their conduct.
You do, but in performing that exercise, you can't escape my submission. It will be necessary to consider what the effect of performance has had on the argument that these were essential terms. Because the Court of Appeal acceded to the argument that the MF1 terms were essential and prevented a contract from coming into existence. Now, as I've been submitting to you...
Did the Court of Appeal hold that the price had been agreed?
I don't know if the Court of Appeal said anything about the price.
Parties have never been in dispute about the price.
Parties have never been in dispute about the price.
They never did say anything about it.
The point which is made...
I don't know what their analysis, on their analysis, what would they have said about the price?
Yes.
Because if the parties were agreed about the price, why isn't that...
Perhaps I can assist. The position was, there was a simple point made that on the contract found by the judge, the documents that he identified do not contain the price. So the contract he found doesn't contain a fundamental term, which rather suggested the analysis he'd undertaken was flawed. But the parties have always been agreed as to the price. It was 1.682 million. It was agreed back at the time of the letter of intent. One sees it right the way through, and no one has suggested to the contrary.
So that at least evidences contractual arrangements between the parties. So there can't have been no contract. Anyway, that's another question.
The Court of Appeal certainly didn't give any consideration to the question as to the effect and the importance of the party's performance. It stops with the analysis that you've got, so far as it goes, and it doesn't continue to ask itself, well, here we are, now knowing that this equipment was all installed, and that now knowing that RTS demanded under invoices percentage of the contract price, and that was paid by Müller. Knowing all of that, do we reach the conclusion that these terms were essential, which apparently they do, and apparently preclude the existence of any contract? Now that, in our submission, was a wrong approach as a matter of analysis, the Court of Appeal were not entitled to conclude that these terms were essential, it not having been suggested at trial that they were, and were not entitled to disregard the performance which the parties had obviously carried out in performing their contract.
I mean, it comes back to what the Court of Appeal was deciding, but at the moment I don't see that the Court of Appeal did decide it by reference to the question whether the conditions are essential or not. They appear to have decided entirely by reference to the scope of Clause 48.
Well,
Last sentence of paragraph 56. Once it's appreciated, the definition of contract in condition 48 covers not just the conditions but the contract, including the schedules, in other words, everything. Condition 48 is a complete answer. All they were saying is there is a legal obstacle to this in the form of, as my lord put, something which is effectively a subject to contract clause.
yes,
Why isn't that the right analysis?
well, that's why isn't the subject contract analysis the right analysis?
Well, why isn't that the right analysis of what the Court of Appeal is?
Well, it's not the right analysis because one goes back to what Mr. Justice Goff said. And what Mr. Justice Goff said has got nothing whatsoever to do with Clause 48.
Well, maybe not, but I mean,
But
the Court of Appeal's reasoning. But
well,
it seems to me to have the reasoning has anything to do with whether the conditions are essential or not.
Well, it records, the Court of Appeal records the submission that my learned friend made on the Court of Appeal that these terms were essential, and you see that in paragraph 52 of their judgment. Mr. Catchpole submitted the way the parties approached the negotiations, referring to the MF1 terms of the contract, and dealing with that first, and then coming on to deal with the schedules, demonstrated first that those terms were essential to the parties. So there is a submission made that these are essential, a submission which I said was not made at trial, was not investigated as a matter of fact at trial, where it ought to have been, if such a case was going to be made.
Whether they were agreed, as my lord was pointing out, doesn't actually matter whether they're essential or not. Parties in the court may infer parties agreed something, even though it wasn't absolutely essential they should, but because it was blindingly obvious commercially that they would have done.
Just going to give a bit more thought to this scenario. We're dealing here with secondary terms, what the liability is going to be for breach of the primary terms.
Yes.
If the parties reach firm agreement on all the primary terms of the contract,
yes,
but haven't reached agreement on the secondary terms of what will happen if they break the contract,
yes,
they go ahead and do their best to perform. And then it transpires that one party has broken his primary obligation. It's quite going to say, well, you destroy all the primary obligations because they hadn't actually agreed the terms of the secondary obligations.
I respectfully agree with that, my lord. Yes, indeed. But that is what the Court of Appeal said in this case. And the basis for their having done so is not that clear. It may be, as my Lord Mayor says, it's simply the Clause 48 point.
Yes, are they not simply ruling on the submission made as recorded in paragraph 56? The point taken by RTS at paragraph 79. Not that I've located paragraph 79.
Yeah, that's our submission, 79. Sorry, where we've...
Well, I was referring to paragraph 56. He...
Yes.
Relied on condition 48 of preventing a contract coming into being on the MF conditions. This I understand to be the point taken by RTS at paragraph 79 of their skeleton argument quoted above.
Yes.
And that's the...
But the paragraph 79 of our skeleton relates, your Lordship's right, it relates to the construction of the clause 48, because one sees paragraph 79 reproduced under paragraph 53 on the opposite page. Your Lordship sees that. So that is the...
Yes, they're rejecting that because that's the limitation of clause 48, so that its only effect is to say you can't have a contract on these conditions.
Yes.
Whereas in fact it says you can't have a contract at all.
Well, in our submission, that's not what it says. It's not the effect that it has.
I'm sorry, but that was their submission in the Court of Appeal, that the Clause 48 had the effect somehow of excluding the agreed MF1 terms, and it's quite clear that these were agreed. Our submission was that when one actually looked at the definition of contract, it was clear it applied, as my lord has said, to everything. And that was the essential debate between us all, because what they have done is pick bits of the agreed contract as defined and said that's a new contract. And we were saying, well, if the judge is right, then clause 48 applies to everything. And on the logic of its own conclusion, there was no contract.
Anyway, paragraph 57, 56, is making 2 points with respect, my lord. First of all, it's Lord Justice Staines's approach, which is to say, let's look at performance, and are we able to treat matters which have not been agreed, but nevertheless there has been performance as an essential. And it's said that that is wrong by reason of something that Mr. Justice Robert Goff said in the BSc case. And it did seem to us that that did inform, rightly or wrongly, how the Court of Appeal approached this case. In other words, regarding as essential the MF1 terms. And it is true that when I submitted at paragraph 60, that the judge had found that these were not essential terms, the Court of Appeal's response to this is not fruitful to get into a debate what is or is not challenging a finding of fact. And then one gets to, in 61, with condition 48 properly understood, and in the context of the importance the parties actually considered the negotiations of MF1 to have, in my submission, given the submissions which my learned friend was making, and given the way in which the Court of Appeal approached it, they do appear to have taken the view that these were in some way essential terms. And if that's what they did, they were wrong. And if that's what they did, it was wrong to allow that point to be taken for the first time in the Court of Appeal. It's a matter which ought to be explored at trial.
And it's 1 o'clock, so let's adjourn until 2.